Before we jump into today's podcast on beneficial ownership information reporting, I'd like to let you know about our webinar on this subject on June 27th and 28th. You can find a link to the registration page in the show notes. Or if you're listening to this after the 27th of June, 2023, we've released our white paper on the subject, and that will also be linked in the show notes.
Welcome to the Treasury Update Podcast, presented by Strategic Treasurer, your source for interesting Treasury news, analysis, and insights in your car, at the gym, or wherever you decide to tune in.
Welcome to the Treasury Update Podcast. My name is Jason Campbell, Business Development Leader here at Strategic Treasurer, and I'm really excited about this topic. I think our audience is going to be engaged and probably listening and pretty good, especially because it's kind of a newer topic than what we've done previously, or probably what many of our listeners may not even know a whole lot about. So it's great. So talking with me today is our Managing Partner and Founder of Strategic Treasurer, Craig Jeffery. Craig, welcome to the show.
It's good to be on and talking about regulations. Those are many people's near least favorite topic to cover. But I'm glad to cover these things with you, Jason.
Regulations, I look at regulations as it's kind of like a box, as you will, right? In a box, meaning there's four lines of a boundary. And I think regulations are kind of always important to make sure that, again, we've got to spot check people. We got to make sure there's things in place. So completely understand how that all kinds of, kind of falls into place. And, and the other thing is with regulations or a regulatory, somebody watching over you, like a watchdog, as you will, making sure that you don't overstep, make sure it keeps you in line, make sure that you're not going to do anything that's going to, potentially have some severe consequences, because obviously I don't know about anybody else, but I don't look good in stripes and orange jumpsuits. So I'm trying to avoid that at all possible. I'm sure many people are too. Really, when we think about today's subject, beneficial ownership information reporting, it's kind of new. There's going to probably be a lot more buzz towards the latter part of the year, because there's a nice little deadline coming up with this. And it'll be here sooner rather than later. And that January 1st, 2024 deadline is going to be quickly approaching. So Craig, what I want to do is I want to kind of talk to you a little bit about this. We'll call this acronym BOI, B-O-I for short, because I'll be honest with you, beneficial ownership information reporting is a little tongue-tying. So we're going to call it BOI. So just kind of give us a rundown of what BOI actually is.
Sure. So beneficial ownership information reporting is what we're referring to as BOI. And this is a requirement to report beneficial ownership interest, the interest in particular companies. The background for this, flows from the Corporate Transparency Act, or CTA. So the goal is to make sure that there's reported information on who are the beneficial owners of different entities. And this, primarily relates to LLCs, partnerships. You might see that as joint ventures, et cetera. So it's really designed for that. And the purpose of this is for the ability for law enforcement, NSA. This is a U.S. regulation managed through FinCEN. It's to, I'll read part of it, it's to help prevent criminals, terrorists, proliferators, and corrupt oligarchs from hiding illicit money or other property in the United States. So this is to pull it up, create some sunshine for this. So it's really providing a complete trail, or a significant trail, for some of those organizations that can be hid under different company ownership structures. And so this will certainly impact greatly LLCs and some of the different organizations that exist that are smaller. And it will have an impact on corporations. Many corporations will have some intersection with this rule and be required to report beneficial ownership information. And like you said, it's due on January 1st, 2024. And so, as we're approaching summer of 2023, we need to be prepping for that, make sure we have an inventory of what's going on. So that's really the reason for this information. And so this hiding money in the United States, came about from, we had foreign bank account reporting, and this was related to who can transfer money. And so this impacted, foreign subs, foreign entities, where there was some interface with U.S. citizenship. Either it's owned by a U.S. company, or there's a U.S. tax-paying entity, whether it's a U.S. citizen or a foreign national who has to pay U.S. taxes. They're required to report their ability to move funds. They're either a signer on an account or acting with someone or on their own. They could move money. So this was all creating the trail of who can move funds for foreign bank account reporting, because that provides a good trail. If someone's funneling money somewhere, now you can quickly roll up who did it and have that information, especially even years later. If you find someone, you can see where did they have the ability to move money. Beneficial ownership information reporting, for this long monologue that I'm giving you, Jason, is that when there was a number of different kinds of payments being made through COVID and through other areas, it became apparent that some of these entities that were getting benefits and hiding money and being able to own these entities were benefiting from this. And then there was no way to necessarily see who were the beneficial owners. And so this is a way of lowering the bar significantly by reporting this information. And, in conversations with treasurers, people across the treasury space, very few know about this, hardly at all. A little bit more on the lawyer side, corporate legal departments are hearing about this from some of the law organizations that are, studying to see where this comes about. So this is important. And it's similar in a lot of ways to FBAR in its general approach, different purposes. One is who can move money and who benefits from that, right? You might not be able to move any money, but you're the beneficial owner. Money can get moved to you. And now who benefits from it? So this is a way of, I'll say, cleaning up the ownership. And so this is for any way they can tie into it for U.S. organizations or entities, this reporting will be in place.
So yeah, I think it's always funny when we think about deadlines. It's that sense of urgency, and whether you're a planner or a procrastinator, like sometimes I'm a procrastinator, but never miss that deadline. But you definitely want to look at things that says there's no reason to unnecessary stress is what I would kind of call it here, and especially when you have criminals out there. Who knows where, they're trying to hide their money. So criminals beware, because, the regulators are coming down a little bit harder. They're making sure that everything's accounted for. It's going to be a little tougher to hide money in the mattress or the backyard or, maybe some other accounts somewhere that you're trying to shift things offshoring or however you work at it. So, I'd say criminals beware on this topic here. So first, let's talk about, kind of BOI and FBAR, right? So FBAR being foreign bank account reporting, is also kind of their cousins, as you will, right? So not necessarily, from the same lineage, but directly, but obviously they're in some type of comparable form. So we'll just call them cousins for the sake of this topic here. And let's hear from Hezekiah about one of our premier services about FBAR filing.
Are you fed up with the complex and time-consuming compliance demands of foreign bank and financial account reporting? Leave the hassle behind and let Strategic Treasurer ease your filing stress. Our experienced team specializes in understanding and navigating the intricate FBAR requirements. From gathering essential information to preparing and submitting the mandated forms, we remove the headaches while keeping you in full compliance. Contact us today to simplify your FBAR obligations so you can focus on what matters most to your business. Send an email to fbar@strategictreasurer.com.
So Craig, now going back to you here. So let's go into talking a little bit about why does this regulation even exist?
Well, for the fact that there's been regulated entities, oligarchs, others who have hid funds in the United States through different entities and have benefited from some of these different programs that have existed for U.S. companies and U.S. citizens and U.S. employees. So this is a reaction to that, to stop illicit funds, to stop terrorism. Terrorism is obviously funded by money, and this is just another way to throttle that down. And so here's one way that they're trying to close another gap that they've seen.
And so, which obviously, from a terrorist and, how to stop crime and criminal activity itself. And, that's where regulation goes into place, right? And that's usually why we have laws in place to stop criminal activity. So it totally makes sense in the reason why this has come about and the ways to find things in the domestic side of things. So what do organizations or what do we have to do to ensure that we are in compliance?
The final rule was completed on September 30th, but there's certainly more information that's coming out, like the what's in scope and what's not in scope, like what type of entities are in scope and not in scope. It's a pretty large list of what's not in scope. And you can say, oh, we don't have any of these, or maybe we do, or I don't think we do. So the first issue, considering we're talking in the June 2023 timeframe, you're looking at what is our complete list of entities that we own or have ownership in or have responsibility for. So what's necessary? Full inventory of all legal entities. Which ones are subject to it, which ones might be subject to it, which ones are not. That makes perfect sense. So that you can narrow it down to say what can be included here. And then it would be to capture the information for probably both categories. Those are the ones that are definitely included. Those ones you may not be sure of right now, to proceed gathering that type of information. And then, as more information comes out, finalizing those ones that may be a bit iffy to your organization. Maybe, does this joint venture work? Does this standalone LLC work for this particular entity or not? And so all of those will require an evaluation. So some firms, let's say if you're in real estate, you may have many, many LLCs that exist that are, all standalone, or maybe there's certain roll-up structures that exist. You have to look through those and see what makes sense. So on this short podcast, I'm trying to say which ones are in, which ones are out. I think there's still some evaluation. There's still a few areas that are gray, but it's essential during the summer at least to go through and do a complete inventory of what these entities that may be included or will be included, and start capturing that information, finding a home for it, capturing it securely, because it's so crucial. So that's the first step. Then there's the issue of how do you file it, when do you file it, and the timing.
It's interesting. I'm pretty sure there were some aha moments to our listeners out there going, you brought up some good points about, when's the last time we really kind of checked our organizational structure, and do things make sense? And do we have, like you were talking about real estate and properties and whether they're in LLCs and does it make sense? Does the structure still make sense? So I'm all about health checks and, kind of getting a pulse check of, like you said, take stock, take inventory of what you do have. And is it all in the correct ways, in the correct format? And especially because obviously the better that these pieces or these components of your business structure are in an alignment, the easier this process is going to be. And I think really, it's also too from an education perspective and just, after you get in that cleanup, right? It's just learning those next steps, because obviously this is regulation that's going to happen for years to come, and it shouldn't be a surprise. It's a fair warning. It's 7 months away. And I know that Strategic Treasurer, we're hosting a wonderful webinar coming up in June, as well as talking about, FBAR and BOI itself. So there'll be some great information for our listeners. There's time to go ahead and sign up for those webinars and participate. But also too, as well, again, because it's all about getting information, and the more that you have, the more that you're prepared, the better you are at being able to deliver and ensuring that things go off without a hiccup or any type of bump in the road. So Greg, I know we kind of got into talking a little about, the deadlines or I don't say deadlines, but more like the due dates and stuff. But let's go back through and revisit, what is the timing of all of this?
This is really important information, and I find it a little bit confusing if you don't write it on a piece of paper. So are you setting up a new entity or registering an entity, or has this entity been in place? If the entity's been in place or registered by December 31st, 2023, then you have until January 1st of 2025 to do the filing. So right now you have about up to 19 months to do the filing for existing entities. You will want to capture this information this summer. You will want to, get all that information so you can file, sometime during 2024 for existing entities. New entities, once you get notification that your registration has gone into effect or the entity has been created, you have 30 days to put that in place. So, let's say you set up an entity on January 1st, on January 30th, you'd need to file. You get the information, the notification that it's set up, then you have to file by the end of January 2024. So those are two of the deadlines. So I would say the other aspect of a deadline is making sure that you have all your evaluation of the entities done ahead of time, and then you're capturing that information.
So even though this regulation kicks in on January 1st, it's not necessarily a due date as it's more so of an activation date. But the 7 months that we've already previously discussed is leading up to it saying, hey, act now, not put it on the back burner, because at some point, regardless, you're going to have to do it. It's always better to do it sooner rather than later. And have this headache sitting up, this dark cloud of this new regulation sitting over your head. It's probably better for a lot of folks to just go ahead and get out in front of themselves and be able to go ahead. There's steps to take to go ahead and cleanup probably happens to happen anyway, right? So it's probably something else to have that good spot check of knowing that your entities are sitting in the right place. It's knowing who's doing what, the ownership pieces, everything about getting everything laid out and prepared now. So it's not something else you have to worry about when it is actually time. Is that fair to say?
I think that's good. I mean, I would say, you may not know how much work you might have to do, but the first step in doing that evaluation, let's say we have 305 entities. Okay, so you go through the inventory and you determine, okay, 40 of these may be subject to it. 20 I think are, 20 may or may not be, and you go through the process. Okay, this is our universe of what we have to focus on. Now we've limited how much goes on. So what do we do to capture that information, to capture the 4 key pieces of information, the scan of identification, and then how are we going to do the filing? So how is that filing going to work? And then the other process is you need to set the process up no later than the end of this year to capture company applicant information, because when things get set up in 2024, you have to file within 30 days. So you have to have a process in place before you start or as you start 2024. So those are just some of the dates to be thinking of.
Well, and obviously it being an all new process, like you said, it's always good to have, avenues where you can go to get as much of the information and be prepared and be ready, right? It's like you want to be ready before the storm and having all of the your supplies ready to go, right? And just treat it no different here in this aspect with this new regulation. So I know that we talked about things that we need to do now. We talked about reviewing entities. We talked about standalones, and so I just want to see if there was any other pieces that you wanted to add of things that can help our listeners be prepared for this regulation to come into effect outside of those 2 key items that we already discussed.
Yeah, so I'd say just some of the terms that you'll become more familiar with. When something's new, it's always like, wait, what are the terms? What do they mean? What's included? What's not? And we can quickly factor things in our head or come up with ideas in our head of this is how it works or this is how it doesn't work. And some of those can be wrong. So gathering that information is vital, but also understanding the terms and reading through a bit of this content is going to be crucial for organizations. And this may land more in the domain of legal than Treasury, but Treasury, I think, can play a significant part in this, especially because they're usually involved in foreign bank account reporting. Whereas foreign bank account reporting is either Treasury or tax tends to be responsible for this. I would say that, for beneficial ownership information reporting, that's going to be legal or Treasury or a combination of the two. But just a couple terms, reporting companies, there's reporting companies, beneficial owners, and we have to also come up with the term company applicant. So I'll just go through those real briefly. This is easier to read material on it than it is to talk about it, Jason. But there's 2 types of reporting companies as they define it. And those 2 types are domestic and foreign. So pretty easy to see the difference, right? And so it's, if it's domestic, you file it with a Secretary of State, like I said. It could be an Indian tribe, or Secretary of State. That would cover all the domestic items. So it's U.S. based. Anything foreign reporting company is foreign from the perspective of the U.S. So any other foreign country that's registered to do business somewhere in the United States or Indian tribe area. So all of those entities, wherever they're doing business with in the United States, would count too. Those would be foreign, and the other would be domestic. So that's the 2 reporting companies. And there's quite a bit behind that, but just think about reporting companies. So it's the entities that we're talking about. The second is beneficial owners. And this is, there's a couple different rules about that and what's substantial control and who has, or owns or controls at least 25% of the ownership interest. The 2 tests are, one, if either of these work, you're considered a beneficial owner. You have substantial control over the reporting company, running its business, making decisions, It could even be moving funds, right? That would be considered some type of control. Or you own or control at least 25% of the organization. It's considered ownership interest of the reporting company. And so there's a more refined and defined definition of substantial control and ownership of interest. And so I'll leave that one at that, and then we'll just move on to the company applicants if you want to hear about that. That's the last part, like who's filing to create an entity. Now, it's kind of interesting in this, there's no ex post facto, after the fact. You don't have to go back and say, who did all of this historically? So anybody who had an existing or registered company, as of the effective date, so January 1st, 2024, ostensibly, you don't have to go back and do this identification. Any new companies will have to capture this information. So part of the process of setting up entities now needs to include the checklist, filing company applicants for BOI, for the beneficial ownership information reports. And so the two company applicant persons are the individual who files a document to create the entity, registers the entity to do business in the United States. Those are the ones that count, right? So if let's say you register in Germany, but then you file or register in the United States to do business, the person who does that is a person that would be the company applicant. Person who files in the United States, the person who registers the entity to do business in the U.S. from outside the United States. And the other is the individual is primarily responsible for directing or controlling the filing of the relevant document by another. So just because you control it, but you don't do the filing, you still are a company applicant. So it's who's doing it and who directs it. So those are the two particular requirements.
So Craig, I know that we talked about, again, some, you had mentioned it previously about some key responsible people within an organization that's going to be responsible for the BOI regulation. And if you don't mind, let's just talk for our listeners again, just keep it top of mind here. Who essentially is responsible for BOI in companies?
Most organizations, legal is going to have a key driver on this because they're the ones that are controlling the legal entity hierarchy. Tax may have an influence on what entities are set up. Treasury is going to be reporting and handling the account. So those three are the ones that are going to be involved in it. I would say for most organizations, ensuring that there's compliance from a process perspective, at least setting it up, is going to be legal. I would say Treasury would be most likely the next area. And they may, in many cases, be responsible for doing this filing. If they're already doing things like FBAR filing reporting, they could add this information and push it in, push it into the new FinCEN system for this. Either way, I mean, that's something, just for our listeners to know, we do foreign bank account reporting and bank account management for companies, handle all the filing there, and we will be doing BOI reporting as well. And so this is, these are things that your law group will do, your treasury group will do, or use an outside provider like either an outside law firm or a firm like Strategic Treasurer to do this.
So obviously this concept, this regulation here is fairly new for many folks. And I'm sure a lot of people are wanting to know, how do I get more information? Where do I go? And there's different avenues for organizations to help, get that information and to help with the reporting requirements. One of the great things that we do have is we have a great webinar that folks are more than welcome to attend by going to strategictreasurer.com. And also look in the show notes. You'll be able to find a link to our June 27th and 28th webinar, specifically talking about FBAR and BOI filing. So really excited to be a part of that with Craig. You and I are going to be, providing some, exceptional information during those webinars. And so please join us for one of those. Craig, thank you so much for being with us today. We really appreciate it as always. And to our listeners, thank you so much for tuning in to this episode of the Treasury Update Podcast. And until next time, take care.
You've reached the end of another episode of the Treasury Update Podcast. Be sure to follow Strategic Treasurer on LinkedIn. Just search for Strategic Treasurer. This podcast is provided for informational purposes only, and statements made by Strategic Treasurer LLC on this podcast are not intended as legal, business, consulting, or tax advice. For more information, visit and bookmark strategictreasurer.com.